Hello, this is Chuck Stevens, and for the next hour, I'll be reading from the Toronto Star, the May 13th edition, here on the Niagara Frontier Radio Reading Service. The jury at Chris Sharif's trial was never supposed to know about the hearsay gang evidence a pair of confidential informants allegedly told a junior Toronto police officer. The judge had already excluded that information from Sharif's trial, but then the jury heard it anyway. According to the top Toronto law firm, now representing Sharif, that revelation, plus what they characterize as anti-black racism, amounts to the miscarriage of justice at the heart of why the former soccer star has spent the last 14 years in prison for murder. We believe that he was wrongfully convicted, said Samara Sector, a partner in the Addario Law Group. She and lawyer Rebecca Amoa have spent a year digging into Sharif's case, prompted by a Toronto Star investigation and podcast. They have taken the case pro bono and are in the process of drafting a special application to the Federal Justice Department. Sharif was convicted in 2012 of first-degree murder for driving the getaway car for the daylight killing of furniture maker Bishan Golab. Sharif is now in his 14th year of a life sentence, serving his time in Collins Bay Institution near Kingston. They are amazing lawyers, Sharif said in a recent telephone interview. I really appreciate what they are doing. It may seem like a small thing, but when I call them, they know my case right off the top of their heads. That's not something I experienced before with other lawyers. Golab, 34, was shot dead in August of 2009 as he leaned over a low fence on Mount Olive Drive in North Otokopi, to ask barbecue guests if the food was ready. Although there were no eyewitnesses nor forensics linking anyone, Sharif, age 19, and Awet Asfaha, 24, were arrested within hours because a car they were in had been spotted in the area. An all-white jury of 11 people, the lone black juror was excused by the judge for health reasons, convicted Asfaha and Sharif, who are both black, of first-degree murder. The Crown's theory was that Sharif, driving his mother's car, purposely stopped around the corner from the barbecue to let Asfaha out to commit the shooting. The Crown contended that Asfaha shot Golab and then returned to what the court labeled the getaway car. Sharif testified this was not true. He told his 2012 trial he was simply driving Asfaha home, stopped his car at Asfaha's request, and waited. He said when Asfaha returned, he had no idea a man had been shot. The trial focused on the question of gang membership, and that is where Sharif's new lawyers believe they have found a miscarriage of justice. Golab, the victim, was a father of 5 with no gang ties. Police said he was in the wrong place at the wrong time. Asfaha had a criminal record for drug dealing, but no gang ties. Sharif was a former soccer star recovering from injuries and was a few weeks away from starting a union job as a carpenter's apprentice. He had no criminal record, and despite Toronto police homicide and gun and gang detectives scouring their records leading up to trial, investigators found no gang involvement. At trial, there was no forensic or eyewitness testimony linking Sharif to the crime, and DNA evidence raised against him was later found to be the wrong DNA. Then, almost on the eve of trial, a junior Toronto police officer with no involvement in the case surfaced with what he said was damning information from 2 confidential informants. Detective Constable Aman Nassar told prosecutors his informants told him Asfaha was putting in work to join the Jamestown Crips street gang. Sharif, the informant said, was the leader of the Jamestown Crips subset called the Hustle Squad. One of the sources even told Nasir that Sharif had bodies to his name according to court documents. The informants both received compensation, either cash or a reduction in other pending charges for the information, according to court documents the Star obtained. Under Canadian law, their identity remains secret to this day, and they were not required to testify. Sector Sharif's new lawyer said she was moved by the Star's investigative reporting on the case. When the lawyer reached out to Sharif in prison, she had a sense that she could make a contribution. I was inspired by his patience and kindness, she said. I wanted to see for myself if anything I could do to help. Sharif's lawyer spent months going over the original trial transcripts, the decisions made at various levels of courts that heard the case, and delved into social science research related to police expertise in gang membership. It's in relation to Nasir's testimony that Sharif's lawyers believe they have a case to prove his innocence. What the jury should not have heard about Chris Sharif. Well, on May 3rd, 2012, in the absence of the jury trial, Judge Eugene Estruck made a ruling about Detective Constable Nasir's evidence. Court officials had previously told the Star they could not find the transcript of this ruling, but Sharif's new lawyers have since unearthed the documents. They reveal that Awaschuk would allow general testimony from Nasir about some of Sharif's friends, along with a photo of Sharif with the men, but was excluding Nasir from relaying to the jury that his sources told him of Sharif's membership in the Jamestown Crips. But when Nasir testified, that's exactly what he did. Nasir labeled Sharif as the leader of the Hustle Squad, which Nasir said was part of the Jamestown Crips. Sharif and several friends later testified that was the name of their pickup basketball team because they hustle on the court, and that the photo court saw of Sharif and his friends was taken after a friend's funeral. Justice Awaschuk didn't curtail Nasir in front of the jury, according to the trial transcripts. Indeed, the judge, in his charge to the jury, repeated Nasir's evidence about Sharif being in a gang. Sharif's former lawyers didn't raise Awaschuk's previous ruling, nor did other lawyers who argued Sharif's appeals at the Ontario Court of Appeal and Supreme Court of Canada. Sharif lost both appeals. His new lawyers want to change that. It was obvious that the hearsay from a confidential informant should never have been admitted, Sector said in an interview. However, when we were looking at the issue, we started to wonder, why was Nasir testifying at all? Confidential informants are treated with kid gloves in Canadian courts. Once someone is labeled a CI, they remain anonymous. They never testify, and defense lawyers cannot cross-examine them to see if what they're saying is true. Everything Nasir relayed about his CIs at trial has since been adopted by subsequent courts. In the Supreme Court of Canada case, records dismissing Sharif's appeal, the court notes, at trial, a police expert in street gangs testified that, according to confidential informants, Mr. Sharif was a member of a gang involved in a gang war. In the Star's original investigation, the Star spoke on background to senior Crown attorneys and defense lawyers who said they had never seen a case where a police officer was allowed to use hearsay evidence in this way. Why did the court let a junior cop testify as an expert witness? Sector further questions why Nasir, a junior officer at the time, was ever allowed to provide expert testimony on gangs. She noted that the legal world has changed its approach to this sort of testimony since the case was tried in 2012. Recent social science evidence suggests that this kind of police expertise often has anti-black racist underpinnings, Sector said. Just because a group of black men are associating, playing basketball, hanging around at a mall, does not mean they are gangsters, she said. The new research reveals that, at times, a police officer's expertise amounts to stereotypes and generalizations, she said. In Sharif's case, Nasir was qualified by Awaschuk as an expert. Sector has concerns with that and notes that judges have a gatekeeping role when it comes to vetting expert witnesses. She said an expert needs to have a methodology and evidentiary foundation for their opinion that can be tested. None of that was provided by Nasir, according to transcripts of his testimony. Sector said current research in Canada and the U.S. shows that at times courts and police conflate racial identity with gang identity. Her firm has retained an academic, Rakesh Walters, who has specific expertise in the way the Canadian state has criminalized black culture and black connection. There are two avenues for Sharif to get a new hearing. First, Sector and AMOA are preparing an application to the Federal Criminal Conviction Review Group, which comes under the Federal Justice Department and is set to eventually be replaced by a new body called the Miscarriage of Justice Review Commission. Under the current process, the Justice Minister has the power to order a new trial or to refer the case to a provincial appeals court. The second avenue is a faint hope appeal, which can be made when an inmate serving a life sentence reaches 15 years of their sentence, which Sharif will reach in October. Sector is considering making that appeal, but acknowledges that in the faint hope system, the inmate typically must admit some level of accountability for the crime to get an early release on parole. Sharif has said for years he will not do this. In the days before his first-degree murder trial, he had the opportunity to plead guilty to a lesser charge in return for a shorter sentence. He declined to do so. The problem is, Sharif told the Star, "I can't take accountability for something I didn't do, and I won't do it." During his time in prison, Sharif has completed dozens of education modules, joined the prison Toastmasters Speaking Club, and has a position as an inmate representative, helping to mediate disputes with prison staff. Asfaha is in prison in Western Canada and is not pursuing an appeal. He has declined the Star's request to interview him. In our next story from the Toronto Star, the front page of the May 13th edition, report urges Ontario to boost funding for special education. Schools diverted hundreds of millions to cover costs. Dozens of Ontario's school boards are spending almost $400 million more on special education than the province provides, says a new report from the Auditor General that urges the government to address long wait lists for assessments as well as create consistent levels of care for kids. The report, released Tuesday morning by Auditor Shelley Spence, notes that of all 72 boards, 46 spent an additional $397.9 million on special education, which includes children with behavioral, intellectual, and communication issues, as well as those with physical disabilities. At the same time, 26 boards spent less, $51.2 million in total, or about 7% of their funding. School boards have allocated funding to special education programs from other budgets because they have identified this as necessary to try to meet the needs of this vulnerable population, the report states. This can negatively affect other education programs and services, impacting the daily lives of students, parents, guardians, and teachers. In 2023-24, there were 334,860 special needs students in the province, or about 16% of total enrollment. Boards have to understand that these children have rights and that they need to be supported appropriately, said parent advocate Susel Munoz, whose 4 children are on the autism spectrum and attend Toronto Catholic schools. Overall, board spending on special education has gone up 19% from 2019 to 2020 to 2023-24, while ministry funding increased at the rate of inflation, or 15%, from $3.1 billion to $3.6 billion. Education Minister Paul Calandra has said he is looking at resources allocated for special education, and on Tuesday said he wants to look at funding to date and have we improved outcomes for those students. However, the auditor's report says parents and educators alike have raised concerns about staff shortages, student safety, budget pressures, and the quality of programming and supports provided to students with special education needs. The auditor looked at 3 boards, Toronto Catholic, Peel, and Upper Canada, and found about 1 in 3 students in Toronto and Peel who needed assessments languished on a wait list for more than a year. Upper Canada, however, had no students waiting longer than a year for psychological assessments. It also found no consistency among the boards or even in schools within the same board with regard to the number of educational assistants, known as EAs, assigned to work with students. This report is another damning indictment of a government that has abandoned its responsibility to Ontario's most vulnerable learners, said David Maston, president of the Elementary Teachers Federation of Ontario, in a written statement. Among the recommendations is for the ministry to set base standards for student care and support, and for boards to have a master wait list to prioritize assessments. Because the longer children wait for assessment, the longer they wait for in-class supports, when early intervention is often key. The audit also said that given high absent rates among educational assistants on a typical day in the 23-24 school year, 18% were away. The ministry needs to better monitor absenteeism, including frequency and reason, as well as the qualifications of those who fill in. Principals, teachers, and EAs across all three school boards told us that high EA absenteeism is largely driven by elevated stress and frequent student-related physical injuries, the report says. These issues, in turn, stem from increasingly complex student needs, behavioral issues, and challenges managing high-need students in large classrooms. On Thursday at the Democracy Forum at Toronto Metropolitan University, hosted by the Star, Calandra was asked about concerns around special education. He said teachers are very frustrated. They're frustrated that they feel they're not getting the support that they might need in order to help every child. Christina Kennedy's twin daughters were put on a wait list for assessment in October of senior kindergarten at their Toronto school, and they didn't get to the top of the wait list until the winter of grade 2. So that would be at least two and a half years. During that time, they received no support, though now they receive occupational and speech therapy. Kennedy worries that other high-functioning children are the kids that really fall in between the cracks because they're not disabled enough to be in separate school. But they're also not able to function in the regular classroom. They end up not getting the extra help. You're listening to a reading of articles and features from the Toronto Star here on the Niagara Frontier Radio Reading Service. Don't forget, all your favorite content is always available on wherever you find your podcasts. Our next article, Complaint Last Summer Spurred Probe into Counselor. The OPP investigating politician accused of soliciting money from developers. The complaint that appears to have prompted a police investigation into a Scarborough City councillor was referred to law enforcement last summer, according to Toronto's ethics watchdog. The Office of Integrity Commissioner Paul Muldoon confirmed Tuesday that it received a complaint about Councillor Parthai Khandelwal on July 8, 2025. The watchdog said it passed the file to the Toronto Police Service 2 weeks later on July 22nd. Toronto police haven't confirmed when they were made aware of the allegations against Khandelwal, but have said they referred the matter to the Ontario Provincial Police in order to avoid any perceived conflict of interest. The OPP's investigation is ongoing, according to the provincial force. The authorities and Khandelwal haven't divulged the nature of the allegations against him, but as the Star reported on Monday, the investigation appears to be focused on the councillor's dealings with developers. One source who spoke to the Star on condition of anonymity due to fears of political retribution and professional fallout said they were left with the impression Khandelwal wanted a substantial payment to allow a development in his ward to proceed. Khandelwal, who was elected to represent Scarborough Southwest in November 2023, has denied any wrongdoing and has said he has strived to maintain the highest standards of ethics and integrity. I'm still learning about these allegations, and it's not lost on me that they've come during the election period. Regardless, my intention is to respect the process and let the OPP complete their work, he said in a statement on Monday. The councillor has said he learned of the investigation last Friday. The Integrity Commissioners is responsible for investigating potential breaches of Council's Code of Conduct. A spokesperson for Muldoon wouldn't provide details of the July 2025 complaint, but said that under the City of Toronto Act, The commissioner is obligated to immediately refer the matter to appropriate authorities if they determine there are reasonable grounds to believe the criminal code or other legislation has been violated. Under the Act, the commissioner must also suspend its investigation pending the outcome of police probe and any resulting charges. The commissioner wouldn't say who filed the complaint or confirm news reported Tuesday by the Star that it was lodged by a representative of the owners of a development in Candoval's ward. The company's lawyer said that someone acting on behalf of the corporation called Kennedy Road Holdings Ltd. complained to the commissioner. The lawyer wouldn't say what the complaint related to, other than to stress his clients were under investigation. The OPP has sought information about the Kennedy development as part of its probe, according to a source. The company's representative filed the complaint less than 2 weeks after its development at 708-712 Kennedy Road went to City Council. Staff had previously expressed concerns about the size of the project just south of Eglinton Avenue, which proposed 682 units in 2 towers of 21 and 42 stories. On June 9, 2025, the owners offered the city a settlement that would resolve their appeal of the project at the Ontario Land Tribunal. They proposed reducing the height of the highest tower by 4 stories and providing 1,500 square feet of non-residential space in the building. A source who spoke on condition of anonymity because they were not authorized to share the information, said that at Council's June 26, 2025 meeting, the city's solicitor recommended in a confidential report that the city accept the offer. Candoval moved a motion on the second day of the session amending her advice, however, directing council to approve the settlement, but attaching a requirement that the developers provide 4,000 square feet of non-residential space. Last October, the Land Tribunal sided with the company and said that amount wasn't justified. Toronto's municipal election is October 26. Before news of the investigation broke, Candoval said he planned to run for re-election. He is not yet registered. Nominations open May 1st. Our next article from the Toronto Star, in the immigration page, would-be Canadians frustrated by delays. A year after applying for citizenship, these Americans feel like they're at the back of the queue. Jolie Rotter and her family applied to reclaim their Canadian citizenship even before other Americans started jumping on the bandwagon. But now they feel punished for filing their application too soon. Rotter lives in Washington. Her paternal grandfather was born in Raynham Township in Ontario in 1909, but worked in Buffalo, New York, and kept residences on both sides of the border. Her father, now age 80, was born in the U.S. and still visits his cousins in Fort Erie and Haldimand County, Ontario, every month, and they celebrate Canada Day together. My dad was raised as a Canadian and has always identified as a Canadian, said Rotter, who still visits relatives in Ontario when she returns home to Buffalo twice a year. He's gone back and forth so much for his whole life that for a long time it really didn't matter whether he had a citizenship certificate. It wasn't until COVID that it mattered, when we couldn't see our family in Canada. The two decided to apply for their Canadian citizenship by descent a year ago, after they learned Ottawa was ordered by an Ontario court to change the law to restore citizenship to lost Canadians and those who would have been affected by the previous 2-generation cutoff rule. The legislative amendments were delayed numerous times since the original court ruling in December of 2023 because of delays caused by the opposition parties in the minority Liberal Parliament. The Rotters didn't want to wait any longer and submitted their Canadian citizenship application last May under an interim measure sanctioned by the court before Bill C-3 passed on December 15th. Now, a year later, the two are still waiting to hear from the Immigration Department as they see others they meet on social media groups who applied after the new law took effect, receiving their citizenship certificates. It's definitely frustrating, said Roeder. When I submitted an application with birth certificates, I feel it should be fairly straightforward, but it just continues to sit there. And I think that's where some transparency from Canadian immigration would be really helpful. It's just this big mystery where other things are speeding through. The Immigration Department said it had received 8,200 applications under the interim measure for a discretionary grant of citizenship as of December 14th. About 1,690 individuals were approved, and there were no refusals. With the measure eliminated on December 15th, officials said the remaining files were moved to the regular queue with first-in, first-out processing. Buffalo resident William Segner, whose maternal grandfather was born in Calgary, belongs to a group on Reddit created by people to share information about the process and the documentations required. They also share their application information and timelines in an Excel file to track processing. There's people who could be fifth, sixth generation Canadians, far further removed than I am, and have never lived in Canada, said the 32-year-old urban planner, who accompanied his ex-partner to Canada for school in 2018 and worked in Vancouver for 4 years. They submitted after the law was passed and are having their things processed and having certificates issued. Based on the shared information of the Reddit group, Segner has the impression that most of the people who applied under the interim measure have been referred to the Immigration Department's Program Support Unit. The unit is responsible for handling complex files. He said he fell in love with Canada during his stay and would like to move back to Vancouver, where he has strong personal and professional connections. As soon as he heard about the interim measure, he and his mother started researching family records and gathering documents. They applied in March of 2025. Segner has not received any update, and like Roeder, only found out through an access to information request that his case, too, has been referred to the Program Support Unit. I understand processing takes a long time, sometimes, especially with the influx of applications, he said, but there doesn't seem to be any rhyme or reason for how they are processing these applications. And for those who filed after December 15th. The Immigration Department said it triages applications by complexity, and those considered complex, such as proof of citizenship applications on the basis of citizenship by descent from individuals born abroad beyond the first generation, are referred to the special unit for assessment. It also said officials processed about 6,280 applications for proof of citizenship between December 15th of 2025 and January 31st of 2026, of which 1,480 were confirmed as a result of Bill C-3. While proof of citizenship applications are processed in order based on the date they were received, unless deemed urgent, complex applications take longer to process, the department told the Star. Joan Ellen Sullivan's case was flagged urgent according to the department's case file obtained under an access to information request. An international graduate from George Brown College, the American from Buffalo submitted her citizenship application in August of 2025. She has been out of status in Canada since January. Her paternal grandmother was born in Kamloops, BC, and moved to the U.S., where her father was born. He became a citizen by descent under the changes made to the Citizenship Act in 2009. Raised in a cross-border family, Sullivan said she always wanted to live in Canada and came in 2007 to study at the University of Toronto and returned in 2021 for the Assaulted Women's and Children's Counselor Advocate Program at George Brown. I've submitted my dad's citizenship certificate and my grandmother's birth certificate. It was very straightforward, she said. They took all those urgent applications and just parked them. The Immigration Department did not explain what's holding up the applications of Roeder, Signer, and Sullivan, but said they are still in process. You're listening to a reading of articles and features from the Toronto Star on the Niagara Frontier Radio Reading Service. Thanks for joining us. Our next article, Bearing the Brunt of Drug Crisis: Why Women, Gender-Diverse People Face Far Higher Risk of Overdose Death. Homeless women and gender-diverse people in Toronto are at a much greater risk of fatal overdoses when compared to men, according to a recent study. Women and gender-diverse people living on the street often face higher levels of violence, trauma, and safety concerns, and may also avoid mixed-gender shelters where they don't feel safe, said lead author Farah Ali, a scientist at the Center for Addiction and Mental Health and assistant professor at the University of Toronto. Consequently, they may use in more hidden or isolated settings, which increases the risk of fatal overdoses. At the same time, access to harm reduction services are not evenly distributed, and in our study it was only actually lowest in women-only shelters, Ali said. So when you combine higher exposure to risk with lower access to protective services, it can help explain why they're seeing such a disproportionate impact. The study, published in BMC Public Health in late April, used publicly available data to examine patterns of homelessness, shelter service use, and mortality. The researchers found that men formed the majority, 57%, of Toronto's homeless population, and were more likely to be shelter users at 58% and living outdoors at 68%. But unhoused women and gender-diverse individuals are bearing the brunt of the overdose and drug poisoning crisis. Among the homeless population, overdose was the cause of death for 76% of women and 80% of gender-diverse individuals, compared to 48% for men. Gender-diverse individuals represented less than 1% of the outdoor population, but accounted for 20% of outdoor deaths. Homeless women and gender-diverse individuals are also dying younger than their male counterparts. 60% of women who died were aged 20 to 39, while men tended to skew older. 46% who died were 40 to 59. The median age death for homeless women in Toronto was 36 in 2024, down from 43 the prior year, with the leading cause being overdoses. Simone Sutherland knows all too well how precious life can be on the street. Before 2015, she had a 4-bedroom house where she lived with her children and partner. My partner targeted me and took my kids away, she said, and I ended up losing everything that I had. That experience, along with childhood trauma and losing several loved ones, left her in a dark place. She started using crystal meth heavily and lived in a tent and around Sanctuary Toronto, a church and drop-in, for 6 years. She said she was careful about her drug use, taking steps to only buy from trusted sources and not use in isolation, but she also faced numerous barriers in obtaining the help she needed. We go unnoticed. We're scrutinized, we're victimized, we're also preyed upon because we're seen as vulnerable and easy to manipulate, Sutherland said. This is especially true for young, vulnerable women and girls, she added, who are often lured with the promise of drugs or cash and then coerced into sexual favors or sex trafficking. When they are no longer of use, the predators dispose of them, leaving them to fend for themselves on the streets. Sutherland managed to get housed 2 years ago and is now in recovery from crystal meth. Ali said while physiology could play a role in the state of overdose deaths, they're seeing between men and women, for example, how drugs are metabolized, body composition or drug tolerance, and sensitivity. Those factors don't explain the magnitude of the disparity they're seeing. Ali said the most likely driving force is that there are fewer harm reduction services available to women and less shelter capacity. In Toronto, there are more men-only beds, 37%, then women-only beds at 18%. The study notes that while harm reduction availability was limited in all shelter types, it was lowest in women-only shelters. Only 26% offered the service. Our findings highlight a mismatch between need and response, Elise said. The people who are experiencing the highest burden of harm, in particular women and gender-diverse individuals, are not the ones the system is designed to support. Our next article from the Toronto Star: Ontario owes families $2.1 billion in child support. Report points to enforcement problems at Family Responsibility Office. Families are owed $2.1 billion in overdue child and spousal support from Ontario's Family Responsibility Office because of enforcement problems, a new Auditor General's report has found. The office that oversees unpaid child support payments was one of 4 government programs that were examined by Auditor General Shelley Spence in a report released on Tuesday. Spence's special report also exposed inadequacies in special education programs in schools, the training of commercial truck drivers, and the implementation of artificial intelligence, including its use by physicians. The Family Responsibility Office, known as FRO, has faced auditor criticisms in the decades since its inception in 1987. Spence's report found it takes an average of 8.5 months for families awaiting money to have their cases registered by the FRO, double the provincial agency's target time. Fully 22% of cases took more than a year, she added, highlighting the risk to vulnerable families. In single-parent households, child support is an important part of family income and makes a difference in children's lives, Spence noted in the 232-page report. Despite handling 30,661 fewer family support cases than 5 years ago, a drop of 21%, the FRO continues to have trouble meeting other service standards with roughly the same complement of staff, Spence said. For example, case management officers did not answer 65% of phone calls or respond to 24% of their voicemails within 48 business hours. There may be opportunities to reallocate staff to improve on the service delivery targets that are not being met, Spence said, citing an internal 2024 analysis of the agency's frontline staff. While she noted FRO's support payment collection rate of 66 to 68 cents per dollar owed has been stable over 5 years, the $2.1 billion stands out in the report as a failure in enforcement. In the 2024-25 fiscal year, roughly 38% of cases made payments on time, an equal share made partial payments, and nearly 1/4 paid nothing. Enforcement options include wage garnishments, suspension of driver's licenses or passports, and registering liens against private property. We concluded that many of FRO's systems, processes, and policies to enforce child and spousal support obligations were not consistently effective, Spence wrote. More than 116,000 families rely on the FRO, which enforces court orders for the payment of child and spousal support. A 2010 auditor's report highlighted its troubles collecting unpaid support, creating undue hardship, with 80% of calls not reaching a representative. Spence made 11 recommendations, including better oversight of enforcement and the documentation of reasons for not taking action to collect money. She also called on the office to calculate interest owed on supporting court orders in arrears moving forward and add those amounts to outstanding payments. To deal with the overpayment issue, Spence said the office should develop a time frame to identify such cases and return money within 6 months. Collecting amounts greater than the court-ordered obligation can have a negative financial impact on a payer, the report said. New Democrat MPP Lisa Gretzky, Windsor West, said the report shows that the Family Responsibility Office is failing Ontarians who are already struggling. Families are simply trying to keep food on the table, pay rent, and cover basic needs, while support payments sit tied up in delays and government failures, said Gretzky. People are frustrated, and rightfully so. Families are being left without answers, while the Ford government continues to look the other way. Interim Liberal leader John Fraser said the report shows a tired, directionless, and out-of-touch government that lacks oversight, refuses accountability, and is increasingly incapable of keeping Ontarians safe. Next up, an interesting article on AI hallucinations found in doctors' notes. Ministers respond to issues with unapproved AI use and truck driver training. Auditor General Shelley Spence released 4 audits Tuesday exposing issues in the government's use of artificial intelligence and the training of commercial truck drivers, along with the Family Responsibility Office and Special Education. None of her reports in 2026, Spence told reporters, will dig into Premier Doug Ford's purchase of a private jet, contending that all her staff are committed to other audits. Spence found concerns about the use of AI when doctors meet with patients. The AI Scribe transcription app used by doctors instead of taking notes was problematic, with evaluators noting inaccuracies in the medical notes generated by most of the approved vendors' AI Scribe systems that included AI hallucinations. Spence also flagged concerns with staff in the Ontario Public Service using unsafe and unsecured websites on phones and computers supplied by the government, creating risks of potential unauthorized data exposure. By allowing staff to use unapproved, unsafe, and unsecured AI websites, the auditor concluded that the Ministry of Public and Business Service Delivery is not preventing potential serious data misuse by third parties. Minister Stephen Crawford said those issues were found during the training period, but would not say if all public service workers are currently using the government-approved Microsoft Copilot chat. The government, Crawford said, has a terrific cybersecurity team to oversee any issues. On the trucking front, trucker training, problems include falsified certificates from unregistered private career colleges that were working with registered colleges to enter student records into the Ministry of Transportation system. Noting the audit examined issues raised in previous years, Transportation Minister Prabmeet Sarkera said the government has zero tolerance for any of those bad actors, and his ministry's enforcement unit has done 50 inspections on schools since last fall. Some of the operators have been shut down, Sarkera said, and in some cases OPP have laid charges. Sarkera said his ministry accepted all 13 of the auditor's recommendations. Interim Liberal leader John Fraser said the need for police investigations into some schools shows the government has no control over the training. You're listening to a reading of articles and features from the Toronto Star on the Niagara Frontier Radio Reading Service. Don't forget to download our free app from your app store and get it on your smartphone where you can access our live stream and, of course, all the podcasts you love to listen to. In sports, from the Toronto Star, Hamilton set to land an expansion team. Steel City will join Detroit and reportedly Las Vegas among 4 new franchises for next season. Hamilton is getting a professional women's hockey league team. Multiple sources have told the Spectator that a deal is done to bring an expansion franchise to TD Coliseum. An official announcement will be made Thursday morning at the downtown arena. Morgan Firestone Arena in Ancaster is expected to serve as the team's practice and training facility. This is part of a 4-team expansion that will take the league from 8 to 12 teams. Detroit has already been officially introduced as one of the new cities, and reports say Las Vegas will be announced on Wednesday. Hamilton will become the first PWHL city that doesn't also have an National Hockey League team. There is no local owner or ownership group here, as all PWHL teams are owned by the league itself. That means the league chooses and assigns the general manager who will assemble the roster. This is going to have to happen relatively quickly, since the window for expansion teams to begin negotiating with available players, there is no traditional expansion draft this time, opens up May 28th, barely 2 weeks away. Then the annual amateur draft set for June 17th. This means Hamilton won't just have a team in name, but an actual team, or at least a significant portion of it, just a month after being admitted to the club. That leaves roughly 5 months to get everything else in order before the puck drops on the regular season in November. Two players who will surely be mentioned often as possible candidates to become the face of the franchise, or faces, plural, are Hamilton's Sarah Nurse and Burlington's Renata Fast. Both are multi-time Olympians with big-name recognition in this area who happen to be free agents. Hamilton jumped into serious contention after a game in the league's takeover tour back in January attracted more than 16,000 fans. Since then, rumors have been circulating. Over the past few days, as these rumblings grew louder and louder, opinions divided social media. Those who disapproved of the idea said Toronto already has a team, and putting another so close is overkill. It would be better to geographically expand to Calgary, Edmonton, Chicago, Denver, Pittsburgh, or any number of other suggested cities. However, those who supported the idea pointed out that a franchise in Hamilton will create an instant QEW rivalry with the Toronto Scepters and a broader Ontario rivalry with the Ottawa Charge, while drawing fans from the city as well as surrounding areas such as Burlington, Kitchener, Niagara, and even London. This is becoming a remarkable year for Hamilton hockey because the arrival of PWHL franchise will coincide with the relocation of the New York Islanders American Hockey League team to Hamilton. That squad will begin playing out of TD Coliseum and practicing at Harry Howell Arena in Watertown beginning in the fall. A name and logo will be released on May 21st. It means 3 professional franchises will now be calling the renovated arena home, including the Toronto Rock lacrosse team that's about to begin play in the National Lacrosse League Final. That series opens on Friday. This is all going to offer local sports fans a smorgasbord of choices next fall and winter. It's also going to lead to unprecedented competition off the ice for fans' eyeballs and dollars. It's also going to mean more dates with the lights on at the arena. That should mean more people downtown on more nights, which should benefit restaurants and businesses in the area. At least that's always been the argument. This is the ultimate test of that theory, because we've never before had this many tenants at the arena at one time. Also in sports, Luukkonen and the Sabres get even. The goalie makes 28 saves in his first start in 3 weeks to beat the Canadiens. Zach Benson scored the winner. Ukko-Pekka Luukkonen stopped 28 shots, and the Buffalo Sabres held off the Montreal Canadiens 3-2 in an intense Game 4 of long reviews, weird bounces, and numerous penalties, tying their second-round playoff matchup at 2 games apiece. Matthias Samuelsson and Tage Thompson, on a fortuitous deflection, also scored for Buffalo, and the Sabres responded after dropping games 2 and 3 by a combined 11-3. Luukkonen stood tall in his first appearance since a Game 2 loss in the opening round against the Boston Bruins. He replaced Alex Lyon after back-to-back lopsided defeats. Alex Newhook and Cole Caulfield replied for Montreal, which went 1 for 7 on the power play. Jacob Dobies made 19 saves. Benson put the Sabres ahead 3-2 with a power play goal at the 4:41 mark into the third period when he shoveled a backhanded past Dobies from the edge of the blue paint while Jake Evans sat in the penalty box for holding. The Canadiens had failed to capitalize on a 4-minute man advantage from late in the second into the third period, with Luukkonen denying Ivan Demidov and Nick Suzuki missing the net on a grade A chance. Later in the third, Doby slid across the crease to rob Consta Helenius on a 2-on-1, dropping his stick to make the save and breathing life into the Bell Center. Doby's denied Helenius again, with under 3 minutes left, this time with the blocker to keep it a one-goal game. The Canadiens goalie then left for the net for an extra attacker with 2 minutes remaining, but Montreal couldn't muster a quality chance before time ran out. The renowned Bell Center atmosphere, earning praise on social media across Canada and south of the border, was jacked up following Sunday's win and hit another deafening peak before puck drop after the energy rattled the Sabres in Game 3. This time Guy Charbonneau, captain, the last time the Canadiens won the Cup in 1993, carried the ceremonial torch into the lower bowl. Cheers hit ear-splitting decibels when Doby's was introduced before the crackling crowd sang "O Canada" in full voice. The visitors opened the scoring at 6:32 into the first period, when Samuelson finished a pretty passing play with Josh Norris and Josh Doan on the rush, with the Sabres dominating the shots 8-1 early. But a successful challenge by Canadiens coach Martin St. Louis, alleged goalie interference, brought back a goal by Consta Helenius, completely swung momentum and sent the crowd into a frenzy after the 10-minute delay. The series shifting back to Buffalo, Game 5, Thursday night, before returning to the Bell Center for Game 6 on Saturday. You're enjoying features and articles from the Toronto Star here on the Niagara Frontier Radio Reading Service. And from the business page, FIFA tickets hitting 64,000 despite anti-scalping law. Provincial government says it's in discussions with resale companies. Hundreds of tickets for Canada's June 12th World Cup opener against Bosnia and Herzegovina are still up for sale online, reselling sites for more than 10 times their original asking price, despite Ontario's new anti-scalping law. New amendments to the Ticket Sales Act make it illegal to resell tickets to any event in Ontario, including 6 Toronto games, which are part of soccer's global showcase, for more than their face value. Monday evening, one pair of tickets with a face value of just over $3,000 a seat was listed at StubHub for $64,462 per seat. Another pair was going for $63,647. While those are a far cry from the $2 million a seat some prime tickets for the final in East Rutherford, New Jersey are going for, it's just the type of makeup the amendments, which went into effect April 23rd, were supposed to eliminate, staggering prices. A spokesperson for Stephen Crawford, Ontario's Minister of Public and Business Service Delivery, said the new law aims to keep fans from getting gouged. "We have no tolerance for bad actors trying to overcharge families," said Crawford spokesperson Gualano Paquin, who warned that companies who don't take down listings for tickets priced above their face value could be fined up to $250,000. These changes reduce the use of bots and bulk purchasing, curb price inflation on the resale market, and give Ontario fans a fair chance to buy tickets at a reasonable price. Under questioning from NDP MPP Kristen Wong-Tam in the Ontario legislature Monday, Crawford said the government is in touch with resale companies. Letters have been sent to all companies. We've been in discussions with every organization that is a reseller of tickets, and we will be continuing discussions with them and will be further enhancing enforcement in the very near future, if not in compliance. In a written statement, a spokesperson for StubHub said the company is keeping a close eye on new listings to make sure they don't break the law. "We have implemented changes so newly listing tickets comply with Bill 97, while we in the entire industry await further guidance," said the StubHub spokesperson. The guidance is coming in a technical briefing for the ticketing industry May 26 by staff from the Ministry of Public and Business Service Delivery and Procurement, according to a ministry letter obtained by the Star. If you, your members, and/or your clients have questions about business obligations related to the purchase of event tickets, Consumer Protection Ontario would like to offer the opportunity to provide an informational webinar, the letter said. At SeatGeek.com, the handful of tickets still being sold for Canada's opener appear to be much closer to their original prices, with the most expensive listed at $4,394, including a $3,765 for the ticket itself and a $628.92 ticket fee. A SeatGeek executive blasted the new law, saying it will force eager fans to seek seats on social media or other sites which don't guarantee tickets are legitimate, unlike major reselling sites like SeatGeek, StubHub, and Vivid Seats. Price controls on resale don't lower what fans pay for World Cup tickets or any other event. What they do is push transactions off regulated platforms like SeatGeek to Kijiji and Facebook Marketplace, where there are no buyer protections and fraud rates are nearly 4 times higher, said Joe Freeman, SeatGeek's Vice President of Government Affairs. Fans don't disappear when resale is restricted. They just lose their safety net. After the new law came into effect, FIFA removed Toronto Games from its own resale site. The changes caught the ticket resale industry off guard, according to industry sources, who said the Ontario government had invited companies to submit their comments on the proposed changes during a consultation period that wasn't scheduled to close until May 10th. Instead, the changes to the Ticket Sales Act were passed April 23rd as part of an omnibus budget bill. If the pricey tickets do not get taken down, however, that raises the risk of eager fans getting pushed to sites where they're at risk of getting scammed, warned Detective David Coffey. One of the groups that will definitely benefit from this law, and it's sad to say, will be the scammers, because it will create more of a scarcity for the buyers. Whenever you have scarcity and high demand, that's the feeding ground for the fraudsters, said Coffey, who works for the Toronto Police Service's Financial Crimes Unit. You're going to have buyers going to those illegitimate sites because there are going to be no other options, because there aren't going to be any tickets for sale on legitimate sites. For Coffey, the World Cup coming to town is a bit of deja vu from when Taylor Swift played 6 concerts of her Eras tour in Toronto in 2024. Emotions, said Coffey, overcame judgment, and fans spent thousands of dollars on tickets that didn't exist. We really didn't know the extent of it until the day of the concert, and people would show up to the stadium and suddenly be told, sorry, this ticket has already been scanned 9 times. You're out of luck, said Coffey. In addition to keeping their emotions in check, fans should also be wary of claims that seem too good to be true when considering whether or not to buy tickets listed on social media or classified ad sites. You're basically throwing your money into this big pot with the expectations that this person that you're communicating with online, who you've never met, have no history with, that they're going to be true to their word, said Coffey. You ultimately just have to be very suspicious. You've been listening to a reading of articles and features from the May 13th issue of the Toronto Star. Your reader has been Chuck Stevens. Thank you for listening.